morning's docket. That is case number 108747 in the matter of the estate of Kenneth Lee Butler.
May it please the court, my name is Jada Kerr and I represent the estate of Leo Butler. I would like to reserve 2 minutes of time for rebuttal.
2 minutes is granted.
This is an appeal from a probate case in Wyandotte County. I'm going to ask the court to do 3 things today. I'm going to ask them to find that the June 2007 order is not appealable. I'm going to ask them to find that the April 2012 order of partial distribution is properly before this court and should be set aside, and ask that this case be remanded and the funds be distributed to my client. I'm also going to ask you to find that the June 2007 allocation is void. If I could review a few facts, first of all. In 1985, Kenneth Butler designated his parents as the beneficiaries under his ERISA governed retirement plan. His mother predeceased him, leaving my client as the sole surviving beneficiary. The plan
How do you come to that conclusion?
Come to that conclusion because that is the named beneficiary on the beneficiary form. And the Colgate plan...
By contract, it says if one beneficiary is deceased, then the other one takes the whole thing?
It does not say that by contract, but Colgate, that's how they administer their plan. If one beneficiary predeceases the other, they pay everything to the surviving beneficiary.
So the probate judge erred when she found that there was a lapse, basically applied the law that governs last wills and testaments rather than contracts, didn't she?
Yes, and at that time, the way that order was obtained, the probate court may not have been informed of what the retirement plan said.
Let's be more basic. How does a proceeding under Chapter 59, a probate proceeding, have jurisdiction to determine a contract matter?
It does not have jurisdiction. Under ERISA, ERISA supersedes any and all state laws. And so, if I may direct your attention to this email, we have an email from the Colgate plan administrator to counsel.
I'm more basic than
Okay.
ERISA, okay? That decades ago when I practiced in probate, the rule of thumb was if you're trying to get property into an estate, you have a Chapter 60 action. If someone's trying to get property out, you have to have a Chapter 59. Why wasn't getting these retirement benefits, whether they're severance or pension, into the estate a Chapter 60 matter?
They should have never, they were not estate assets. They were simply supposed to be distributed according to the Colgate-Palmolive plan. So they should not have been distributed into the estate. They should have been distributed to my client. If we look at, there was 2 options under the supplemental retirement plan, and if the first option would have been selected, if you could move that. I'll go over the options. If the first option was selected, a portion of those benefits would have been distributed into the estate of Kenneth Butler. The allocation order selected option 2 and then distributed those benefits on a percentage based on intestate succession law. All the estate was asked to do by Colgate was to execute a waiver for these supplemental retirement benefits, and then to either select option 1 or option 2. What happened is the attorney went in with a pre-drafted order and selected option 2, and instead of paying the benefits to my client as directed by the Colgate-Palmolive plan and by ERISA, distributed those benefits, paying $176,000 to the estate of Kenneth Butler and only $63,000 to my client.
Your client had notice of that hearing, though, correct?
My client was disabled, a double amputee living.
Did your client have notice of that hearing?
He had notice of the hearing, and he was told he did not need to come because all that was going to happen was going to be the selecting of these options.
Told by whom?
He was told by Colgate, and then Diane Durbin was the counsel at that time. She had communications with the attorney, and all that was going to be done was to select either option 1 or option 2. We had no notice that there was going to be an allocation of percentage of benefits.
And did your client, Leo, the father, accept the $63,000? Was that paid to him?
It was, but it wasn't paid out for many years because after this allocation, after option 2 was selected and the allocation was made, Colgate refused to follow that order because it didn't comply with their plan. So after a couple years, they finally paid out money. They paid $204,000 to the estate and
Okay,
the
okay,
$63,000
and that
to my
went,
client.
my point is, that went from Colgate to Leo,
Yes,
and it never went through the estate.
no.
And he accepted that. He took that
Yes.
money. Why isn't that an acquiescence into Colgate's allocation?
Colgate had paid my client many benefits because he was the sole designated beneficiary. He received life insurance benefits, many other benefits. The only point of contention were these benefits. So he did accept the portion from Colgate, but the remainder of the money is in the estate of Kenneth Butler.
Counsel, before you proceed, I think
Yes.
the court has had a real good view of your 2 exhibits. Would you mind setting those on the floor so the audience can see
Yes.
what's going on?
Yes,
Thank you.
thank you. So we are here today because in April 2012, after the money was paid into the estate of Kenneth Butler, pursuant to that June 2007 allocation, counsel went in to the probate court, filed a petition for partial distribution, asking that money be distributed to his client. We did not get notice of that petition for partial distribution. The petition and the order for partial distribution are date and time stamped at the same time.
Okay, now, this was partial distribution of the assets of the estate.
That had been paid in by Colgate pursuant to that June 2007 allocation.
And your client was not entitled to any benefits from the estate as a beneficiary of the estate.
Not
Is
as a
that correct?
beneficiary, correct.
And
Not
did
as-
your client, so what your client is complaining about is that the estate took property that should have belonged to your client, correct?
Yes,
And in the normal circumstance where an estate gets property that someone else claims, they file a demand against the estate, a petition for a demand. Was there a demand made by your client against the estate for wrongfully taking his property?
there was not a demand against the estate, and we're here because of that, because we're appealing the June 2007 order, which the district court found that we should have appealed in 2007. However, that was not appealable in 2007 because it was not a final order. After that June 2007 order, further action was needed. The further action that was needed was the partial distribution. That's why we're here today. We're asking that the June 2007 allocation be set aside because it's in violation of ERISA. And we're also asking that the April 2012 order of partial distribution be set aside because of the way it was obtained by counsel, again, filing the petition for partial distribution without giving us notice. A certificate of service.
I don't understand why you were entitled to notice if you were entitled to nothing under the estate.
We were entitled to notice because counsel knew we were an interested party. There is a certificate of service attached to that petition, but it was never sent to us. The order of partial distribution was also never sent to us.
Your client was harmed when the money went from Colgate to the estate instead of to him. He's claiming he was entitled to have it come directly to him from the company as a matter of contract,
Yes.
as a beneficiary under that pension plan. So his harm was when it went to the estate. And his duty was to go after that money for wrongdoing on the part of the estate. But once it's in the estate and it's time to distribute, it's too late for him to complain about being harmed in 2007, isn't it?
Not in our opinion, no, Your Honor, because the only reason Colgate didn't pay the money to my client was because of this June 2007 order, which is not appealable because it was not a final order. When you have a petition for partial distribution, you ask the court and tell them why the funds should be distributed in this way, and then the court has the opportunity to either say, yes, they should be distributed in this way, or deny it. We didn't get the opportunity to object to that petition. Like I said, counsel attached a certificate of service, but it wasn't sent to us. We didn't get notice of that order. An order of partial distribution is appealable, which is why we are here. The district court found we did not get notice of that, and they found that that was excusable neglect. But again, they went back to the June 2007 order.
And why is the June 2007 order not a final and conclusive order resolving all issues regarding who has the right to that pension?
It is not a final order because further action was needed from the district court.
Yeah.
Specifically, the further action that was needed was a petition for partial or final distribution, asking the court to distribute those funds and telling them why they should be distributed in this way.
Why was that necessary? Wasn't the point a declaration of what option to take? Wasn't that the issue before the court? Why was a further order of distribution necessary to the order that had been made?
If the money, the allocation order, all it did was divide into percentages, and it didn't comply with the plan, so.
But the point again being that the plan shouldn't have been in the estate, would have been separate from any further action in the estate. So once the administrator asked for the guidance on that one issue, why wasn't that final and conclusive?
It wasn't final and conclusive because you still have to distribute the money out of the estate. And at that time.
Why wasn't it final and conclusive in that the estate, which is an entity, wouldn't you agree, a legal entity, the estate was a legal entity, possessed that property in derogation of the rights of your client and was claiming that property to be its own? And it's no different than if the sole beneficiary, Franklin, had possessed it. It was possessed by a legal entity claiming rights superior to your client. So why isn't that the point at which you have a right to seek redress?
Once the money is in the estate, it still has to be distributed.
But nothing was going to be distributed to your client because your client had no right to the estate.
My client had a right to those funds, so the order of partial distribution, the petition for partial distribution could have came in and said, in reviewing the Colgate-Palmolive plan, in the attorney's conversations with Colgate where he was told how the money was supposed to be distributed, this is how it should be distributed. It should have been distributed to Leo Butler.
So you're saying that when the court distributes a decedent's estate under the statutes in Chapter 59, it can ignore the laws of intestacy and distribute based on pre-deceased contractual rights? Because you were claiming rights, or your client was claiming rights under a contract that was entered before death. But how do the pre-death contract rights trump the Chapter 59 rules on who the judge is to distribute the property.
ERISA is very clear that any state laws should be superseded by the plan itself, by the Employee Retirement Benefit Plan. There are many Kansas cases and Supreme Court cases explaining that when there is a clash between state law and the provisions in ERISA, state law cannot stand. States are not free to change ERISA's structure and balance. That's from Boggs versus Boggs, a U.S. Supreme Court case. So when you're asking me, how the probate court can make a determinant of intestate succession, that wasn't an issue in this case because we have federal law and we have the ERISA governed retirement plan already telling us how those benefits are to be distributed. The probate court cannot ignore that federal law. If we look at the U.S. Supreme Court case of Engelhoff versus Engelhoff, they say this is exactly why ERISA is enacted. It's so that administrators can simply identify beneficiaries specified in the plan documents and do not have to familiarize themselves with state statutes. If without ERISA, we would have plan administrators. Colgate is a large corporation. The decedent was living in Wyandotte County. My client was disabled, living in a retirement home in Florida. This is the type of case where a plan administrator under ERISA simply needs to look at the plan, read the plan, and the plan is very specific that only when a member fails to designate a beneficiary will the beneficiary be his estate.
So what I hear you saying is, now the plan administrator would have been Colgate.
Yes.
And what you're saying is Colgate did not follow the rules of the contract or ERISA when it paid the money to the estate.
Colgate.
Isn't that where the problem was, is ERISA paid the $176,000 to the estate?
Colgate had planned to pay the money to our client, but based on this June 2007 allocation from the Wyandotte County Probate Court, that is the only reason they didn't pay the money to our client. They even communicated with the attorney and communicated with the probate court saying this is how it's supposed to be distributed, but that order, that allocation was never set aside. The court just kept saying, you should have appealed it, it was a final order.
But I'm back to who's got the obligation to follow the ERISA, the plan administrator or the decedent's estate administrator?
They both have the obligation to follow ERISA. I mean, it's very clear under Kansas law that when the federal law says the plan administrator should administer the plans in accordance with how the plans are stated and how the decedent, contracted for the money to go to his parents, that is what the plan administrator did. So the probate court was obligated to follow that retirement plan, and when they did not, that was an error, and that is why we're here today. They could have corrected that order because it was not final when the distribution came out. Again, we had a pro tem judge signing that order, and the petition and order are date and time stamped at the same time. So there was no real consideration given to the Colgate plan at that time, which it should have been. That petition, we got no notice. We did not get notice of that order, which is what the district court ruled, and that's why we're here today, asking you to consider that order, look at the plan as it's interpreted by Colgate and federal law, that those benefits are payable to my client.
Counsel, I see you're out of time.
Okay.
Do you need 30 seconds to wrap up, or do you want to wait till your rebuttal time?
I'll wrap up. The point of this case, it's been going on for a while, is that the June 2007 order was not final, it was not appealable. At that time, we were relying on Barfoot, and it's not appealable because after that order, you need to distribute the funds by a partial or final order of distribution, which is why we're here today under that order of partial distribution, asking that that be set aside and that the funds be distributed according to the plan. Thank you.
Do we have any more questions?
I just want to clarify that you agree that your client's entitlement to those funds flows from the pension contract, correct?
Yes, from the retirement plan.
And your client has no claim to any benefits from the estate.
The estate is by intestate succession. My client is solely by contract with Colgate, yes.
In other words, your client's not a beneficiary of the estate, but just a contract beneficiary of the pension plan.
Contract beneficiary, and then the only reason we don't have those funds is because of that June 2007 order. Thank you.
Thank you.
Good morning. Bruce Hanson for the appellee, Frank Birch, who's the administrator of the estate. I'd like, if I could, to cut through the haze a bit and get to the essentials of the case, starting with jurisdiction. The appellant made a decision not to appeal an order entered in the probate court of Wyandotte County back in June of 2007.
Why did the court have jurisdiction to enter that order of allocation?
Your Honor, there was a petition that asked the court to do so.
Well, I understand that, but why does a probate judge handling a Chapter 59 proceeding have the jurisdiction to direct a plan administrator how to issue benefits pursuant to the contract that it's administering?
Your Honor, I was not trial counsel at the time. I do know from the record that in the actual order issued by the court allocating the benefits, they referenced the fact that Colgate had authorized the estate to choose an election in accordance with a determination to be made by that court as to the best interest of the estate. I think there was some agreement that the court had some jurisdiction to consider that issue.
Aren't there two issues there, though? One issue is which option you take in terms of how that money will be paid. But the court then took a second step and decided who would receive those monies under those options. Wasn't the acquiescence only to the option one, the first part of it, which was selecting between the two options?
It appears to me that what the order is saying is that Colgate will respond by transferring assets to the estate in probate court of Wyandotte County based on how that court decides the proper allocation to be. The plan itself was silent on a situation of what happens when a beneficiary predeceases the employee. The jurisdictional problem is that once that order was issued, the appellant decided not to appeal. They also did not appeal the 2008 motion to set aside that 2007 order. They did not appeal the amended order thereafter. The Court of Appeals held that the 2007 order was a final order as to appellant's rights, and his right to appeal then became subject to the one critical precondition, which is time. They did not file within time. I think clearly they regret that decision. They then went to the federal district court and filed there, then the 10th Circuit Court of Appeals, and back to the probate court, then the Kansas Appellate Court, and now here. This court has stated that the Supreme Court has no jurisdiction to hear appeals not filed within the statutory time limits. The court was explicit in Giles versus Russell, 222 case 629. And that's the status of as to the 2007 and 2008 rulings. In the absence of compliance with the time limits, this court has a duty to dismiss the appeal as to those rulings. The 2012 ruling was on the motion for distribution to the heir. And the court then held that the appellant is not an interested party on that issue and therefore has no appeal rights.
Why was there a certificate of service on that petition? to them? Do you know?
My understanding is that in the front of the file in the office is a list of parties, counsel, people who have had some interest with a small I in a case. And routinely, when matters happen in a case, those people are given notice. There was no agreement that they were an interested party with a capital I and a capital P, because, in fact, you know, that's a whole different interest. I can address interested party for a second. Maybe we can roundabout way get to answer your question.
Let's try and start this way. Were you the lawyer who filed that petition for partial distribution?
I was one of the lawyers, yes.
Okay.
Yes.
So are you telling me there just wasn't any consideration by the lawyers handling that filing as to whether they would be listed for certificate of service?
We noticed everyone for service, including the former trial counsel and the counsel for Mr. Butler.
And but there was a decision made at some point after their listing was made on the pleading not to follow through.
They were
Or-
served.
Okay, your
Yeah, they were
opponent said
served.
they were not, I think.
They said they didn't receive the service, and I appeared in court and I said, if they say they didn't receive it, I believe they didn't receive it. But we sent it,
Okay,
so,
all right.
and we filed the certificate accordingly.
The disconnect was somewhere between. Okay, thanks.
Yeah. Question then, are they an interested party? In 2007, appellant clearly was, because the court was being asked to make a decision as to the rights of the appellant to the allocation of the pension benefits that were claimed by the estate. But that was the sole controversy at issue in the district court in 2007, the allocation of those funds. The appellant had no other claims or issues pertaining to the estate. When the Wyandotte County District Court ruled on that issue 7 years ago, and when the appellant made the decision to not appeal within the 30 days, then his role as an interested party ended.
When did Colgate pay out the funds? Your opposing counsel said it was a couple of years later before they paid out the funds.
The complication was that appellant filed in the federal district court in Kansas. Colgate, in due course, paid the sum due under the pension contract into court in the federal court. And not until that decision was rendered and the 10th Circuit appeal was dropped was an order then issued by that court to distribute funds. So it took a while. Colgate didn't take a while, but took a court process a while.
And when that process was over, 63,000 was distributed to decedent's father.
Yes.
Okay.
Yes.
And they accepted that money.
As far as I know, yes. Those distributions were made by the court.
Counsel, I'm a little confused between these two orders and what notice was sent on which order and which notice was received on which order and who was told what on each order. Could you spend about a minute going through that for the 2007 order?
I think it's stipulated that notice was received by the appellant to the 2007 hearing, and that they, did not attend the hearing, that counsel was retained within the appropriate time limit to file an appeal, but that no appeal was filed. Now, again, I was not involved in the trial level. I was retained once the federal court action was filed. But in the 2012 motion for partial distribution.
Let me talk about 2007.
Okay.
I may be confused or misinterpreted what opposing counsel said this morning, but I understood her to say that even though they perhaps received notice of the 2007 matter, that they were told by somebody not to appear or did not need to appear. Am I confusing the two orders, or do you have any knowledge of what happened in 2007 on that issue?
I think that's what was stated by counsel. I was not involved at the time. I know I didn't tell anyone not to come to a hearing. I never would. I understood the inference being maybe that Colgate or someone that Mr. Butler was relying on said don't come, but it certainly wasn't by me.
Yeah, that's the extent of your knowledge about whether anybody was told not to come.
Yes.
All right, thank you.
Yes. There's no comprehensive definition of interested person in Kansas that I can find. Many states do have a statute of that nature. I don't believe we do. What's typical, I think, is one like our neighbor to the north has, where interested persons are heirs, devisees, children, spouses, creditors, beneficiaries, and others having a property right or claim against the estate of a decedent. The appellant has none of those relationships. He's not an heir, he's not filed a claim, he's not a beneficiary.
Or they're saying they have a property right or claim against part of the assets there.
They did in 2007.
And you're saying because they didn't file a petition for demand of claim that within the, 120 days, that they were no longer had that claim?
At the time of the 2012 hearing, those rights are long gone. A party cannot appeal unless it has a particular interest and is prejudiced by a decision. The interest cannot be speculative. It must be immediate and pecuniary. That's well-settled law in Kansas. The Fort Hayes case in our brief goes into that. And this appellant simply had no such interest. If would you allow me to address for a minute at least the final order and final decision terminology, which seems to be at issue. Appellant's taking the view that the 2007 order was not a final order. The Court of Appeals here described the issue before the Wyandotte Court as the allocation of pension benefits and pointed out that the resulting order, quote, demonstrated finality. Once that issue was ruled on, later actions in the administration of the estate were not going to affect that issue. The Court of Appeals quoted the TSW case for the proposition that the determination by the district court was of, quote, an important issue completely separate from the merits of the action. This court, in ruling in TSW in 2012, and also in the Flores case, which is 283 Kansas 476, said that in construing the statutory jurisdiction for an appeal, the term final decision is self-defining and refers to an order which definitely terminates a right or a liability involved in an action, or that grants or refuses to grant a remedy. And that characterizes what occurred in 2007 in the Wyandotte County Probate Court to determine the allocation of pension benefits. That was a final decision on that issue, and it was intended by such by the district court. And if I may, look at the practical side. You've all practiced too. Look at the practical side of the administration of a probate estate. What we see in this case is a common situation in the process of the administration of a decedent estate in probate court. One case, the Freeman case, which is in our Freeman estate, which is in the brief, stands for the proposition that a final order is a decision which determines a right. In the course of probate litigation, there are many such determinations made by the court. Each of those enables the matter to move along a path toward completion. In fact, even the appellants in their brief acknowledged that within the context of probate, there are many significant rulings as the matter proceeds. And these rulings decide the validity of wills, the establishment of heirs, the legitimacy and amount of claims, many other issues. And these rulings are final orders that determine rights. And each of them is subject to review by an appellate court if the interested party, not satisfied with the determination, chooses to go to the appellate court and seek review. Examples. The order of a probate court admitting a will is a final decision and appealable, which this court determined in a state of Perkins, which is 145 Kansas 611. Similarly, an order of a probate court refusing to admit a will is a final decision and appealable. The Perkins decision gives many citations on that. An order for the sale of an estate asset is an appealable final decision. That arose in a case titled Estate of Pritchard, which is a Court of Appeals case, 37 K.App. 2nd 260, which is a case where retained counsel could have timely appealed the decision to sell that asset, but did not do so, which resulted in the finding and decree of the court for sale of the asset becoming binding on everyone after 30 days. It would be impractical to administer justice within the context of probate estates if those rulings were not final orders, and if only the final settlement of an estate were appealable. One repercussion of allowing an appeal from the order of final settlement to challenge all of the rulings which have come before it would be to give a litigious party an opening to re-challenge determinations that have been reflected in orders over the entire course of the litigation, which is often years in the process, and then if successful in the challenge would require the administration of the state to start anew, adding significantly to the burden upon the heirs, upon the claimants, upon the administrator, both in added time and in increased costs. Failing to allow immediate appeals of critical issues in a decedent estate prolongs unnecessarily the determination of rights. Such a system would be imprudent, and it would not produce a result we could characterize as justice served. The fact that there are further administrative proceedings to be accomplished in a state does not negate the finality of those orders.
Well, Counselor, I understand you're arguing the practical aspects of a Chapter 59 action. If what the judge sitting in a Chapter 59 action did was enter an order that would ordinarily be governed by a Chapter 60 action, is it nevertheless subject to appeal as a Chapter 59, even though it should have been handled under Chapter 60?
Yeah, I think it is. I think partly from the catch-all language in the two statutes versions, the pre-2006 and 2006. And also, an example would be a case like Freeman, where what the probate court did was refuse a transfer to the district court for a hearing on construction of the will, and that was considered an appeal, which would really fall under Chapter 60 law, and it was appealable.
Counsel, I see you're out of time. Would you like 30 seconds to wrap up?
Two quick points. Our statutes have procedures to give appellate courts the opportunity to correct trial court errors, and that is routinely done. What cannot be allowed is a misuse of statutes to circumvent the time limits for appeal. Appellant is attempting to escape from a decision to not appeal a determination made 7 years ago. The actual ruling appealed from is only the 2012 order of partial distribution, which had no effect on any rights of this appellant. And there was an opinion in Tabor, which I could find a site for, Tabor versus Tabor. But I think what the court said, this court said then, was that the role of this court isn't to decide questions when they can have no effect on the actual rights of the appellant. And again, the 2012 hearing didn't really not involve the appellant's rights. He wasn't an heir. He wasn't a claimant. And like here, the Tabor case involved forum shopping, legal maneuvering, and a failure to properly appeal. And in that court, you declined to issue what you said would be essentially a advisory opinion in those circumstances. I think the same would be true here today. And I would ask the court to deny this appeal.
Very well. Do we have any more questions? Thank you, counsel.
Thank you.
You reserve 2 minutes for rebuttal.
I would just like to clarify a few points. There was the question about the petition for partial distribution and the notice. The petition for partial distribution has a certificate of service attached to it. The petition and the order granting it are date and time stamped at the same time. We didn't receive notice of either petition or the order, so even though there's a certificate of service, we did not receive that. And we didn't receive notice of a hearing. It was done in a manner because council knew we had an interest in those funds. The second thing I would like to clarify is there have been questions about the plan administrator and what the plan said. The Colgate plan is very clear that only when a member fails to designate a beneficiary shall those benefits be distributed to the estate. Further, under the Colgate retirement plan, the administrator has the exclusive right to construe and interpret the terms or provisions of the plan. That's the discretion of the plan administrator. Kansas law and federal law is clear that when the plan administrator has that discretion, only if their decision is arbitrary and capricious will it not be followed or upheld by the court. We have this March 2007 email from the Colgate plan administrator to council for the estate of Kenneth Butler explaining the benefits, explaining that my client is the beneficiary for pension and retirement, explaining the estate is the beneficiary for severance. And those two options, only the first option allocates $54,000 for the estate and then $176,000 for my client. But for that June 2007 order, which was not appealable, those assets would have been paid to my client. The estate of Kenneth Butler wasn't required and wasn't asked by Colgate. They didn't need to go into court and ask for an allocation of the order based on state law. The Colgate plan administrator, following the plan and following federal law, had already made the determination under the documents by simply reading them that my client was the beneficiary and they should be paid to my client. With regards to a demand against the estate, we are here because the June 2007 order was not appealable. We didn't make a demand against the estate. We're not a creditor. Those funds should have never been paid into the estate. We are here today asking this court to find that June 2007 allocation is void because it's contrary to the plan documents. It's contrary to federal law, which is very well set out by the Supreme Court and by this Kansas Supreme Court, that if federal preemption preempts the state probate statutes. And that's why there wasn't a demand against the estate. Those funds should have never been paid in. And the June 2007 allocation should be found void. And we're asking that the April 2012 order of partial distribution, which is correctly before this court, which was appealable, should be set aside, and that the funds should be distributed to my client under the ERISA plan.
The notice of appeal was actually filed on the April 2012 order of partial distribution, correct?
It was filed on the order of partial distribution, and the district court ruled, since we did not get notice of that order, that we were allowed that extra 30 days because of excusable neglect. And then they went on to rule.
You didn't have any interest.
They went on to rule we didn't have any interest and that the 2007 order was final.
Did you confirm that that April 2012 order is actually in the record on appeal? Because I believe your brief talks about it, quotes it, but it doesn't have a record site.
It is in the record on appeal, yes.
Can you get us the record site for that?
Yes, I can.
Okay, that'd be great.
Where are those funds now as we speak?
I don't know. The order of partial distribution was in April, and I'm assuming they were distributed out to council's clients, so that might be a good question for him as to what actually has happened to the money.
So the funds, as far as you know, have already been distributed
As-
pursuant to the 2012 allocation?
As far as I know, they have been distributed pursuant to that allocation, and like I reiterated, that that order is appealable, under Chapter 60 and under Chapter 59. It's appealable to this court. So I'm not actually sure what happened to the money, but I know that distribution was appealable, and we're asking that it be set aside.
Any more questions?
Chief. Did the administrator of the estate have the authority to select the option?
Did have the authority to select the option because there were supplemental benefits, and it would have been decedent's election, but since he died prior to electing it, they asked the estate to select either option 1 or option 2.
And so, Mr. Birch, as the administrator, could have elected option 1, and the $54,000 in severance pay would have been an estate asset. Is that correct?
Yes, he could have elected option 1, which would have given the estate $54,000 under the plan. He could have done that, yes.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.